Perfect. We'll be down shortly.
Thank you.
Did he say he'll be right with us? Is that what he's?
He said he'll be down shortly.
Oh, okay.
So they probably have to pull him out of his unit.
Okay.
I don't know what block he's on, so I don't know how close he is to the visiting area.
It's just par for today.
As long as he's coming down, it's all good.
Yeah. We couldn't have something go smoothly today, could we?
Yeah.
I will try not to contribute to your both of your bad days.
No, I think we're good. I think it's all good.
We're in the straightaway now.
Oh, well, that's good.
Yeah.
I just had a quick question. You have an interesting one coming up, I believe, after Mr. Lewis.
No, actually, that's continued.
Oh, okay, good. Then I was
This
going to
is-
say if you would mind if I'd stayed on and watched it because we're so familiar with that case.
Right. Yeah, no, that's been continued. Actually, I need to put that. I do want to put that on the record, which I will do now, just because we're waiting.
Sure.
In regards to the 11:45 hearing for Charles Cornelius, numbered 296776. This case has been continued to be heard for January 29th, 2025 for the preliminary hearing.
That's it, no doubt. No doubt. That's it. You can go right up in here, they should all be waiting for you, okay? All right,
Thank you. Good morning, Mr.
How
Lewis.
you doing?
Good, how are you?
Hey,
Good morning, Marlon.
morning.
Hello,
we're
Mr.
here.
Lewis.
We're here for your hearing today, so we're gonna get started, okay?
All right.
Good morning, I'm P.O. Meisinger, hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Lewis Marlon, number 379405. Today is January 15, 2025. This hearing is being conducted via video at the BOPP Central Office in Garner Correctional Institution. This is a public hearing. Public access to this hearing is available via video live stream. Can you please state your full name and DOC inmate number for the record, sir?
Marlon Lewis, 379405.
And you have parole officer here today. Please identify yourself for the record.
Parole Officer Kimberly Goodman.
And we have counsel here today. Please identify yourself.
Yes, Public Defender Robert Famiglietti of the Parole Revocation Unit. Hello, sir.
This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has responsibility to prove the allegations by a preponderance of evidence, that is. The better weighted evidence must establish that, more probable than not, the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more conditions of your parole, I'll reinstate your parole, which is releasing and place you back on parole supervision. If I find you violated one or more conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I'll make a recommendation as to appropriate sanction, and my recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing would be provided to justify additional confinement. So this is the procedure for today. I'm going to read you your rights. Then we will review the parole violation charge the state appeal is bringing against you. I will review and identify exhibits filed for the record. The state will then have an opportunity to present relevant testimony. After the state is finished, counsel will have the same opportunity. After considering all the evidence presented, I'll announce my findings. If I find you violated one or more conditions of your parole, the state will have an opportunity to speak to your background and history. After the state is finished, you will have the same opportunity. Do you have any questions about the purpose or procedure at this time?
No, Your Honor. No, Your Honor.
Okay. You have important rights today. The right to have an attorney present. You have counsel here. You have a right to receive the written notice of charges of violation. Did you receive the written notice?
Yeah.
Okay, you have a right to view the evidence. You have a right to submit evidence for your case. At this hearing, you have a right to call and examine voluntary witnesses or cross-examine adverse witnesses. Do you understand these rights and are you ready to move forward?
Yes, ma'am.
Okay, so now review the charge. State your appeal is bringing against you and the information allowing you charge. So P.O. Goodman, if you could read the charges, you don't have to read number 1 as a no finding was made at the time of the prelim.
Yes, thank you. One moment, please. Obey all laws. Obedience to the law. On 10/23/24, you made threats to assault Whiting forensic staff, hospital staff on Unit 6. You entered another patient's room unprovoked and physically assaulted them. While the patient was lying in his bed, you jumped on top of him and punched him in multiple times in the face. You were face and head. You were restrained as you presented an imminent risk. You continued to make threats of assault on staff and you spit on the doctor. You had to be moved to another unit. Your behavior meets the threshold for Connecticut General Statute 53A-60 assault second. On 10/24/24, you became agitated and attempted to assault staff on Unit 4. You threatened to stab staff with a spoon. You had to be restrained. You were combative. You bit the inside of your mouth and spit blood at staff. Your behavior meets the threshold of Connecticut General Statute 53A-181, breach of peace in the second. Based on your behavior, you are in violation of special parole condition number 2, obey all laws. Mental health treatment. On 10/24/24, you were remanded from Whiting Forensic Hospital per the request of Whiting staff for threatening and assaultive behavior. Because of your removal for such behavior, you were unsuccessfully discharged from your mental health treatment program. You are in violation of your conditions of parole, additional condition, mental health treatment.
Thank you. And the state is following exhibits that are pre-marked for identification purposes as Exhibit A, signed parole conditions, B, remand national custody order, C, notice of parole violation, parole rights, D, parole violation report, E, Whiting Forensic Hospital integrated progress notes, F, misconduct report, G, DOC disciplinary report, H, email from Dr. Berger, I, documented conversation between PS Mann and Dr. Berger. J, Demas police case incident report. K, email from Lieutenant Driscoll, RE assault. L, assault second description. M, breach of peace second description. N, revocation hearing summaries. O, misconduct report. And P is probate involuntary commitment decree. Did you receive notice of parole violation report, and those other documents I marked? Did you review them, sir?
Yes, we have.
Okay. And council has filed the following exhibit pre-marked for identification purposes. Defense Exhibit 1, list of parole accomplishments and future plans for parole reinstatement. Do you need to continue this hearing to obtain any additional evidence?
No, we do not.
You don't have any witnesses. At this time, I'm going to swear in P.O. Goodman as well as Mr. Lewis in case you want to speak.
I'd ask that you not swear in my client because there is a pending assault charge
Okay.
in Middletown Court. And I'd ask that I'm going to advise him today not to make any statements on the record about
Okay.
what may or may not have occurred there. So, sir, I don't want you to make any statements about what did or occur or didn't occur at Whiting because I don't want them to use any of those statements against you, okay?
Okay.
All right, so, P.O. Goodman, please raise your right hand. You solemnly swear, solemnly, sincerely affirm, as the case may be, the evidence shall give, so in this case, shall be the truth, the whole truth, nothing but the truth, so help you God, if penalty of perjury?
I do.
Okay, would you like to say anything right now in regards to the charges?
Just related to, with regards to the charges, Mr. Lewis was placed at Whiting Forensic Institute on a involuntary probate commitment as he was found to be gravely disabled and a danger to himself and other people. And as evidenced by his behavior on said dates, that was actually probably the best decision that the court could have made at the time. This is also the fourth time that Mr. Lewis has been involuntarily committed to either Whiting Forensic Hospital or Connecticut Valley Hospital because he has been a danger to himself or others. And it is accurate that what Attorney Famiglietti said, that we have learned that there's a pending matter warrant out of Middletown Court that has yet to be adjudicated. Mr. Lewis has a significant history when being out in the community and in the institution, and it should be of note that the violence that he displays is for secondary gain and has been documented multiple times that when he has committed those assaults, he has not been found to be paranoid, delusional, hallucinating, or disorganized.
Thank you.
Thank you.
Okay, turn over to counsel if you'd like to say in regards to the charge.
Yes, as to the charges, obviously a no finding was made as to charge 1. I think a no finding should also be made as to charge 3, because the only reason he was discharged from treatment was because of the remand. It wasn't him not cooperating with treatment. And so I don't believe there was any intent, no action of his own ended that treatment. It was because there was an order remanding him. I have no comment as to charge 2, other than I don't think anyone can jump inside anybody's head, whether you be a psychiatrist, a psychopharmacologist, any type of doctor, trying to estimate or try to understand what motivates someone who has a compromised brain chemistry. There's no such thing as a perfect brain. We all suffer from different chemistry in our brains that causes us to act or not act in certain ways, shape, or form. And trying to assume or judge that someone's mind wasn't compromised when they were acting, when they do carry a diagnosis and they have been involuntarily committed because of their grave disability, I think it's a little presumptuous to assume when someone is acting under color of brain chemistry that's disturbed or not. Thank you.
Excuse me, guys, I'm just wondering if it's gonna be past 12, because if so, I'm gonna have to put them on my count.
It probably cut close to it.
Okay, thank you.
Yes. Okay, thank you. So what I'm gonna do next, is I'm gonna announce my findings, based on evidence and testimony that I have reviewed. So in regards, like we had previously stated, charge 1 is not taken into consideration, no finding was made at the time of the prelim. On charge 2, I do find you violate conditional obedience to the law based on evidence that was provided in support of the charge, which is exhibits A, E, J, K, L, part 1 and A, E, M, part 2. Regarding Charge 3, I do find you violated condition, additional condition, mental health treatment based on evidence that was provided, exhibits E, H, I, and P. So that includes the fact-finding portion of the hearing. Before I make a recommendation, the state will have an opportunity to speak to your background and history. After the state is finished, council will have the same opportunity. This purpose part of the hearing is to help determine what outcome I will recommend. So P.O. Goodman, would you like to say anything at this time?
Yeah, this is the 5th time that Marlon has violated since his release to the community. He's had one escape, which was a Class E felony that he was convicted of while he was at a halfway house. He had one absconding. He had one technical. This would be the 2nd technical. And he had another criminal charge for very similar behavior at Connecticut Valley Hospital. We have attempted to work with Mr. Lewis since 2019, and he continues to be uncooperative with his. He continues to be uncooperative with abiding by his parole conditions of parole. Again, as I stated earlier, a court on 4 separate occasions has found him to be a danger to others, and he has presented that way in the community and in least restricted, controlled environment, and he continues to utilize violence for secondary gain. I don't know how many times a court needs to deem him gravely disabled and a danger to himself or others before we stop kind of putting him back in the community and creating other victims. We have created at this point now, if I'm not mistaken, 1, 2, 3, and potentially with a pending case, 4 victims of Mr. Lewis's violence. And we are recommending a full revocation to be reviewed as policy. I believe it's annually unless that's changed. He would be found gravely disabled and a danger to others again if we released, and at that point would have to be placed back at either Whiting or CVH. I'm not sure how many times we need to do that or how many times he needs to prove to the parole board that he's not a good candidate for parole, even though special parole was ordered at the time of his sentencing. I do want to put on the record that at the time of his preliminary hearing, and it is in the prelim summary documented on multiple occasions, that he claimed that the reason for his behavior is that he was allergic to Depakote. Nowhere in his medical record, and I've checked the EHR with the Department of Corrections and with DEMIS, is there an allergy to Depakote. In fact, his only allergy listed, which is a mild one, is to risperidone. So I want to make sure that that's on the record, that, you know, you can either you're mentally ill or you're not. Not all people who are mentally ill and diagnosed with a mental illness and or are meet a hospital level of care assault people on a regular basis for secondary gain. And it was documented in the reports that Mr. Lewis did not want to go to a step-down unit from Whiting at Dutcher and want to be released to the community, and thought that if he committed these acts that, you know, he would get his way. And I'm sorry to say that it didn't work. And it didn't work the 4 other times that he's been violated as well.
So if he gets, when he comes back out, would he be going back to Whiting or CVH?
Potentially, yes, if he's found to be gravely disabled and a danger to himself or other people. I would say at this point, the answer to that question would be yes. However, I'm not sure how willing or unwilling Whiting and CVH are going to be able to work, because in the past 6 years, he's created several victims, including staff over there. It's not just other people who are struggling and who are mentally ill. He takes advantage of, he assaults the staff, but he takes advantage of people who are weaker than he is. So, you know, he does not have any place to go. That's been presented to us. I mean, I did get the defense's evidence yesterday, and it just says that he's amenable to everything. So I really don't know what that means, because in 6 years, he hasn't been amenable to much.
Okay.
Maybe heard now?
And the other, you know, the other thing I want to say too.
Wait.
The other thing I want to say too is we don't know what's going to happen with the outcome of this new criminal charge.
That's
know, he could-
irrelevant to today's proceeding.
But you put it on the record, so we still
But
don't
it's
know
still-
what's
no,
going to
it's
happen with
irrelevant
it.
as to the decision today.
Okay.
Can I be heard now in this last minute that we have?
You can, yeah, well, it's now going to be your defense's turn, so if you'd like to
Thank you.
speak. Yep.
No, take all the time you want. They can wait for the count. That's
Yeah,
fine.
you're not we're not sending him back until we're done, so you have
Thank
time. Yeah.
Okay, so my client doesn't have a choice here today. He's either going to go to Whiting Forensic because he's been committed there by the probate court. And I spoke with probate court in North Fairfield. So he's the subject of an involuntary commitment until that's changed. So he's either going to be at Whiting Forensic or he's going to be incarcerated. And there's no question he's gravely disabled. So our question today is how much time he's going to serve in jail. Are we going to warehouse him in jail? Or are we going to send him back to the treatment, which he just so desperately needs? What happened on that day is going to be decided in court as to whether or not he's going to be punished. And there's no information that he's not going to be able to go back to Whiting Forensic. He's under an order. That's speculation. So our decision today is what the sanction should be for this conduct. That's our decision today. And I don't think revoking his parole is the answer. My client is 34 years of age. He's involuntarily committed due to his mental illness. He's going to be a danger to self or others, and they knew he was a danger to self or others when they committed him to Whiting. He's going to be a danger to self or others if he's in Whiting, and he's going to be a danger to self or others if he's incarcerated. It's as a result of his mental illness. It's as a result of his compromised brain chemistry. This is like diabetes. This is like a heart condition. My client was born. He's been on SSI disability since he was 16 years of age. He needs management. He needs appropriate treatment. I think it's noteworthy in the Department of Mental Health and Addiction Services Public Safety Division report that both the clients are at end of sentence and have a legal status of probate commitment psychiatric. That's both parties to this argument. The patient did not wish to pursue charges due to not wanting to be labeled a snitch. This is the end of the report from the police that were in charge of managing the situation. The Demas Police Department will not be pursuing criminal charges in this matter. This incident will be handled clinically. It's only afterwards that the warrant was submitted. This type of conduct, unfortunately or fortunately, occurs while someone with a mental illness is in a setting such as Whiting Forensic. The answer is not to take someone with a mental illness and revoke their parole because they are symptomatic. Any conclusion that he was not acting through the filter of his mental illness is preposterous. His personality, his actions, his sense of self-being, his decision-making process is all filtered through his compromised brain chemistry. There's no separating when he's acting one way and when he's acting another way. They're all actions. His intent or lack of intent or acting or inacting is all tied to his decision-making process, which we've known is gravely disabled and compromised. I think if we throw away the key today and send him in jail, that is the wrong answer. Thank you very much.
May I just clarify on the record that the charges that are currently pending have nothing to do with what was charged on this PVR. It's a completely separate incident and not related to any of the charges. That it's a whole nother charge, and it's not charged in this current violation.
Which further proves myself that this is conduct related to his mental illness. You cannot separate his actions and say this is intentional and say, no, this isn't intentional. This is all colored by his mental illness. And persons with mental illness, as decided by the probate court, in this set of circumstances, has placed him at Whiting Forensic. We don't just throw away the key and totally revoke someone's parole because they're difficult or because they're assaultive.
Well, this behavior only happens in the context of when he's released from custody. It doesn't happen if you review,
In the
if you review
past,
his
we don't
DOC
know that.
history. It doesn't happen. It doesn't occur within the Department of Corrections. It occurs upon release.
In the past. There's no reason to take away his freedom any further than it's already been taken away. Thank you.
My understanding is also the facility will have to reapply for another commitment
Fine.
because
Let
that
them reapply.
commitment became vacated. So there's no guarantee he can go to Whiting.
People having to do more work, people having to do their
that's fine.
job,
We
I'm
can
just
do that.
saying, should not be an impediment to my client getting the treatment that he needs. Thank you.
All right, so I've noted what both the state as well as defense has stated. So I'll be right with you with my recommendation.
Thank you.
I will put on the record that the offender was on parole for about 2.5 months before he was returned to custody for this violation. He does have 3 prior violations, a criminal misdemeanor and technical, as was previously stated on the record. So this is his 4th parole violation. He does have a history of violence and absconding, as well as which includes assaultive behavior. And I just want to put on the record too, as well, that I am noting that there are currently pending charges that are not related to this parole violation. So based on this information that I have and on testimony provided today, as well as the interest of the offender, I'm going to recommend that parole be revoked and that the offender be reparoled for January 2nd of 2026. Which is an approximate 1 year and 2-month period of confinement as a sanction, leaving the offender with 1 year on special parole supervision. I recommend the following parole conditions: halfway house placement, no consumption of alcoholic beverages, no contact with victim GHOBMB, behavior management program for anger management, general no contact with 263 Laura Street, New Britain, Connecticut, and mental health treatment and medication compliance. My findings are to go to the parole board January 30th. So the board's going to review this and they're going to make the final decision on what happens. The board can agree with my sanction, they can lessen that sanction, or they can revoke all the special parole as well. So it will be up to the parole board. Mr. Lewis, you'll know on January 30th what the parole board's decision is. And if they're going to re-parole you and if they're going to agree with my date or list a different date. Do you understand that?
So what's going on when I go to probate court?
So I'll explain it to you. Nothing's going on at probate court right now. I spoke to probate court. You're not represented in probate court. You don't have a conservator. That lapsed. What happened today is that the hearing examiner recommended a 14-month sanction. So that is a release date of next January, the beginning of next year. So just over a year, but the time you've done has already counted.
Okay.
That's not a final decision. That final decision will be made by the board, sir, on January 30th. So at the end of this month, you'll find out what your release date is, and you can call me and tell me, and I'll call you and tell you as well. You'll get a letter you'll also get a letter in the mail, sir, from the board telling you when your release date is, okay?
All right.
All right?
Thank you. Thank
You're
you.
welcome. Good
All
luck,
right, you're
sir.
all set for today.
Thank
Bye,
you.
Marlon.
Thank you.
You said January what?
January 30th is the decision. And
Okay,
the release, okay, sir?
all right.
Okay, thank you, guys.
Thank you, guys.
Thank
Have a
you,
good day.
Ken.
Bye, Rob.
Bye.